I guess to get started, I'm going to announce our moderator, which is Adam Steinbaugh. He's, I think this is kind of funny, but he's referred to in one of the articles as a revenge porn vigilante. He basically exposed a lot of the revenge porn website operators a few years ago, so that they could be, because, there are a lot of the issue here is like the anonymity, and he graduated from Loyola Law School a few years ago at the top of his class. Let's do it. And then I will let my counterparts introduce everybody else.
Hey everyone, this is Ken White. Ken White is a partner at Brown, White, and Osborne LLP. He's a former federal prosecutor and currently is a criminal defense attorney as well as an attorney who handles First Amendment issues. You can read about internet issues and free speech issues on popat.com, his blog. And he's worked to expose revenge porn perpetrators such as Craig Ribbit.
And then last but not least, we have Professor James Chen, who is a current professor at Michigan State University Law School, and he is of counsel to the Technology Law Group, which is a DC-based firm that specializes in telecommunications law. In 2012, he was named a top 25 most influential people in legal education by the National Jurist magazine, so we're really happy to have him here. He has many, many years of experience under his belt, and he has experience with law of regulated industries, economics, and regulatory policies. We're really happy to have all three of these wonderful gentlemen here to speak with us today. So help me welcome.
So Nicole asked me to kind of give you an overview of what revenge porn is and some of the, history or legal issues involved in this, because I will set these guys up to discuss it, and they're way behind it. So what is revenge porn? Revenge porn generally is the posting of nude photos without someone's consent. But it's kind of a misnomer, and there's a debate going on about what to label this, because revenge porn, the term revenge focuses on the motivation of the person who's posting it or sharing the image. There's another term, involuntary porn, which kind of focuses on the harmful aspects of it, or the lack of consent. And there are people who have a problem with the term porn itself, because that implies that the people who are viewing this are doing it for pornographic or prurient interests. But a lot of people aren't visiting these kind of websites because they want to see porn. They're doing it as kind of a rubbernecking gossip or watching some of the. Before I continue, I want to make two different distinctions on revenge porn. There are dedicated revenge porn websites which exist solely to spread this kind of stuff and solicit it and to make a profit out of this. But there are also websites which are utilized for the purposes of sharing videos, such as Facebook and Twitter and pretty much any other website you can upload. I also want to make a distinction between criminal prosecutions. There are a number of revenge porn statutes which have been proposed, but a lot of the prosecutions, in fact, every single one of the prosecutions of someone running these websites has been for peripheral acts, so hacking or extortion or some other type of conduct that is not the actual posting of photos. In terms of a brief history of revenge porn, it's not exactly new. Back in World War II, people used to share photos of, the gal back home or that sort of thing. But technology has made it a lot easier to share this very quickly, which has also made it a lot easier to utilize it for harmful purposes very quickly. The first guy to really pioneer this, or the guy credited for doing this, is a guy named Morrill. He ran a website called Anyone Up, which was supposed to be about a band or music of some sort, but he randomly posted photos of someone as a joke, and it went viral and took off. So he decided, I want to get a lot of attention for this, so I'm just going to do this to a lot of people. He did. He was labeled the most hated man on the internet for this. He did this to celebrities and to thousands of individual people. And he got grief what he did is, even though lots of people were sending these photos saying, hey, I want to embarrass this person, he decided that he was going to take some of this money and pay somebody to hack into random email accounts to try and find new photos. And the guy was able to do that. The feds eventually took notice of that and arrested Hunter Moore for violations of the CFAA, essentially hacking, and conspiracy. So he got too greedy and gave them an avenue to arrest him. He just pled guilty and was sentenced in about a month. The next guy was a guy named Craig Brick, and he is the innovator of revenge porn. He decided that, nobody's going to advertise on our website because he wants to advertise on it. So he invented a fake lawyer named David Blake, and he said, listen, you're posted on my website. I went to college with this guy, David Blake, Esquire.
Pardon me, can you play it through? I'm sorry.
Was he always the third, or did that come later?
Always, I think that was one of the few consistent things about this. So he invented this guy and said, if you pay my college buddy, David Blake, who's a public defender in the state of New York, give him $250, he'll negotiate with me and maybe I'll take these down. But otherwise, I have a server that's hosted in Romania and you're never going to be able to get these down, so good luck, screw you. Ken and a lawyer named Mark Randazzo noticed this and challenged the guy saying, you can't find any lawyer named David Blake. And his story fell apart almost immediately. He eventually shuttered his website after the FTC launched an investigation. And about 3 months ago or so, the FTC agreed to settle with Craig Brick, saying, now that you've shut your website down, just promise that you'll never do it again. He doesn't have to do anything else except to tell the FTC where he works for the next 25 years. Doesn't have to pay anyone, doesn't have to do anything else. Another gentleman was named Casey Maring. Casey Maring ripped off Craig Brick's entire website, the extortion element of it, word for word, copy the design, everything. And this guy was homeless and living in Oklahoma City or Tulsa, Oklahoma. And even though he didn't really affect many people because his website was very small, the state of California decided, your website is still up, unlike Craig Brick's. And they flew out to Oklahoma and brought him back to California for extortion. So he's facing trial in June. The next gentleman is named Kevin Bolyar, and I understand that the prosecutor in this case will do it tomorrow. He did a website called You.Posted and was extorting people through another side website that was actually run by him, but he was telling people that it was an independent company. He was sentenced a couple weeks ago to 18 years in prison for extortion and identity, and the state was asking for 10. So this judge was not very happy, and he will be probably the first case of any of these people to potentially reach him. There is one last dedicated revenge porn website of any sort of substance. There's a study going on right now where they're documenting that about 36 people are posted every single day. 95% of them are women. And all of the traffic, almost all of the traffic on the website goes to women's profiles. So that suggests that revenge porn in general disproportionately impacts women. Those guys, when they were first running this website, they were also engaged in some extortion, but they have since fled the United States. Unless anybody wants to go to another continent, they will continue running this website. But revenge porn isn't just on dedicated websites. Sometimes it's newsworthy, or sometimes it's on other websites. So you may recall when Jennifer Lawrence and a bunch of other celebrities had their iCloud accounts hacked into, and their own new photos were posted, and the media blocked this and posted it everywhere. You might recall the appropriately named Anthony Weiner, who sent an image of his wiener to so a lot of women, and they shared it. Now, these statutes that have been passed, they might apply to that conduct because they're involuntarily sharing this photo of Weiner's wiener to the media. So should that be unlawful? I don't know. These guys will talk about that. There's also kind of this weird disparity between how the media treats men and women who are subject to this. When it's a woman who's a celebrity whose photos are leaked, there's more of a defensive, that's very well. But when it's a guy, for example, I believe Hulk Hogan had one of his sex tapes uploaded. they'll post the video right online and say, hey, check this out. It's, there are also a lot of smaller cases. I'm aware of one in California right now where the guy is being charged with stalking and hacking and identity theft and being an idiot. He also destroyed the records because of closing them on us, and he's also charged with theft. Since all of this has come about in the past year or 2 years, about 16 to 17 states have passed these different statutes. I've lost count of how many states have these now. California had one, or has one, and when they initially passed it, it excluded selfies for some reason. So you could be charged and convicted for spreading photos if you took them, but not if the person themselves took them. Arizona also passed one, and as soon as they passed it, a bookstore and a bunch of other companies sued the federal court saying, hey, this statute is overbroad, and it's going to, it could conceivably apply to the things that we publish that aren't revenge porn, it's just art. And the state agreed and said, we agree this is overbroad, so we're going to do a do-over on it. So that, they agreed not to prosecute it going forward. So that is pending right now. I don't believe Arizona has passed their new one yet, but they're about to. And the last issue that I'll bring up is what's called the Communications Decency. The CDA, Section 230, is the law that prevents, if I'm defamed by somebody on Facebook, it's the law that prevents me from going to Facebook and saying, you know what, I'm going to hold you liable for this defamatory publication about me because you were the one who actually published it. Even though it was some other guy who said it, you're posting it. Back in the 90s, the Congress decided that, you know what, we don't want to impose that kind of liability on websites for what other people say. And moreover, we want to give people the ability to remove content without being sued. They should have that option. The CDA applies to these dedicated revenge porn websites, which generally means that they can't be prosecuted in a state court for a state criminal act because of the CDA, and it's difficult to sue. The one thing about suing these guys who are running these websites is they often don't have lawyers and won't show up, so you get a default judgment and eventually shut them down. So that's all I really want to say. So I don't know how we want to start this off.
Can we talk about possible federal criminalization?
Sure. There is a Jackie Slider, I don't know if I'm pronouncing her name right. She's a congresswoman who's proposed, or she's going to propose a federal criminal statute because a lot of states haven't passed their own, and she and a lot of people believe that there needs to be some federal criminalization to go after the people who are actually posting these on websites or operating websites themselves. She hasn't released what the text of that will be, but she's working with people that have worked on a lot of these statutes at the state level, so we can kind of expect that it's going to be the same sort of thing. So with that in mind, I guess I'll just toss out the general question of what problems do we run into with that, and why would the First Amendment apply to that law?
Well, there are legal problems and practical problems. Speaking as someone who was a federal prosecutor, now a federal defense attorney, I think the practical problems are bigger. Really passing a federal law criminalizing something is how we say, look here, we're doing something about a problem without really doing anything about the problem. With resources being what they are, I think there is effectively zero chance that any people who are pure revenge pornsters, the guy putting up his ex-girlfriend's pictures on the web, are going to get federally prosecuted in law or not. That's because the feds are always going to use their resources to go after aggravated cases that have other factors that they can already prosecute. So like you've got Hunter Moore, they're nailing Hunter Moore not for revenge porn, but for his participation in hacking to get the images and for his theft of identity information and for conspiracy. Adam and I put together what I call a red ribbon package. Hey, look, this is everything you need to prosecute this guy on that turd, Craig Britton. I mean, we had names and addresses of victims. We had the Central District. We had communications. We had IP traces showing he was this lawyer, David Blade, who was extorting money from them. I had, these emails from some of these women saying, please, I live paycheck to paycheck. Can you just wait till the end of the month for me to give you this $250? They didn't take it, okay? And it's not because they're bad people. It's because the feds can take very few cases. The vast majority of cases they take are going to be dope and bank robbery, immigration, and anti-terrorism. And the few they take in this realm are always going to have factors that can already be prosecuted under existing law. In terms of the First Amendment issue and the problems with some of the statutes, some of them are distinctly too broad. If you look at, for instance, the Arizona statute, it pretty simply said that it's a felony to publish a nude photo of anyone without their consent. No ifs, ands, or buts. The problem with that, and when the ACLU sued them, this was early on in their complaint, they said, well, it's now illegal for this bookstore to sell this book that has the iconic photo from the Vietnam War of the little girl running down the street having been burned by napalm. Under the statute, literally read, she didn't give consent. Under the statute, it's a felony. That doesn't make sense. So Arizona is going to perhaps come up with something narrower. The problem is there's tension. Everyone wants to be able to get every single revenge porn person out there. But the broader you make it, the more difficult it is to bring it into what has to be narrowly drafted for purposes of the First Amendment. I'm going to stop in a minute to turn it over to Jim, but the primary case out there right now that is a problem for the people drafting revenge porn statutes is a case called the United States versus Stevens from 2010. This is a creepy case. This is about crush videos, which are, some people apparently like looking at women stomping on animals. So there was a federal law against it, because of course there was a federal law against it, because, senators want to be seen as being against stomping animals, and they can beat that by passing a law. So they passed a typically incompetent law that basically banned any depiction of cruelty to animals in videos. Of course, it was completely overbroad, and when it got to the Supreme Court, the Bush administration argued, well, it doesn't matter because you can balance this. Crush videos are of very low social value, very little speech that goes on in them, so therefore, since there's such an interest in protecting animals, you can ban this. And what the court said is this: no, there's no ad hoc, case-by-case value weighing of the value of speech. There are certain established exceptions to freedom of speech. Obscenity, defamation, incitement, things like that. You don't get to just keep popping up new ones, and you don't get to do this balancing test on every piece of speech. If it's not one of the classic areas that falls outside the First Amendment, then it's treated like anything else. You don't get to value it. And a lot of the arguments in favor of the revenge porn statutes that are being proposed in some cases rely on this theory that we can do this because this is low-value speech. We can do this because everyone hates it. And while I certainly agree with that on a descriptive level, I don't think it works on a legal level.
Well, all right, let's go right into the First Amendment issue. And I do want to come back and circle around and talk about 230, which Adam mentioned closed. And I do think that the 230 issue is a very, very legally interesting, legally intense, and in fact, it's a great subject to bring up in a law school setting. And almost clinical opportunity to engage in the important statutes. Let's start with the constitutional claim here. It is true that the First Amendment does say, Congress shall make no law regarding freedom of speech, but it's not an absolute. We know historically that there are certain categories, threats of violence, obscenity, sexualized depictions of children per se, without regard to whether they satisfy a higher obscenity standard. Invasions of privacy and libel, right? There's no First Amendment protection against libel liability for spreading malicious lies about people or putting them in a false light. These things are all within the reach of the First Amendment. I would agree that the Stevens case in 2010, a classic case of a gracelessly drafted statute, bringing in a howitzer to blow away a very, very few, very, very sick people, with a big law that everyone can say, oh, I sponsored that, I voted for it, now we're taking care of fresh videos. And as a result, we're saddled with a case that I would regard as the First Amendment equivalent of Claiborne versus Claiborne Living Center, which is a 1985 case, which actually decided in favor of equal protection claim. But it was one that said, you know, this era when the 1960s and 70s, when this court, the Supreme Court that is, allowed people to come up and create new categories with heightened scrutiny, that day's gone. The opportunity is come and gone. We need to stick with established. What was interesting in Claiborne, and I think applies to the course here, is it then proceeded to say, okay, so the mentally retarded are not a suspect class. We just will not create more suspect classes. And yet, it struck down a hostile zoning ordinance that really took a fight out of the ability of the mentally retarded to set. I think something similar can happen here. Think about the speech value of this kind of depiction, whether you call it revenge porn, involuntary, or non-consensual porn. First of all, porn doesn't get a lot of First Amendment respect to begin with. It's barely tolerated only to the extent that there is, in the words of Morrill versus United States, something big and mystical about sex. But if you're crossing the lines purely prurient interest, we call it obscenity. If you ever involve children, you go straight to jail. Pasco, you don't collect $200, you don't claim the First Amendment, and that this applies to mere possession as well. If you think about the things that make this body of expression socially offensive, many of the aspects of other already established categories of First Amendment law apply to them. Is it a gross invasion of privacy? Yes. Does it put people in false light and say falsehoods? The suggestion, oh, look at this slut. Basically, that's what that says. Does it have any real value besides appealing to prurient interest? The Supreme Court upholds all sorts of expression, okay? Pardon for the use of words, but here they are. Fuck the draft. We'll take the fucking street later. If I ever get Lyndon Baines Johnson in my gun sights, I'm going to pull the trigger. Next time they shoot the president, I hope they get him. I mean, there are incredible numbers of offensive, dangerous things that are all upheld. But guess what? Oh, how about this one? We white people in this country are sick and tired of it, and there's going to be some revengeance taken. Yes, that was the word he used. These are real cases. I'm not making this stuff up, right? The value of those statements comes down to this. I don't like the draft. I don't like the guy who's president. And you know what? I think that a certain race or a certain religion should be supreme in politics. You can say those things in this country. That's what the First Amendment is about. But what is the underlying message of a classic revenge or non-consensual? You know what that message is? Look at this slut. She's so stupid. She slept with a shithead like me. That's the message. The political, social, artistic, scientific value of that message, you've got two choices. It's either 0 or negative. So, I mean, I think even without getting into a metaphysical discussion about whether you can create new categories such as extreme obscene violence or crush porn as cruelty to animals combined with sexual allure equals cruelty to children plus sexual allure. right? The New York versus Ferber rationale. Even without getting into the metaphysics, I think the First Amendment claim in this realm is extremely. Let me throw in one more thing. There's this area, one other area of constitutional law that's actually some relevance to this is substantive due process. And okay, this is probably one of the very first and few times that a speaker recommended by the Federalist Society is going to speak, even vaguely in defense of substantive process. How to speak, acknowledging the substantive process is the law of the land. Whether it should be the law of the land, that's a different Federalist Society meeting. Perhaps we can speak about that at some other time. But it is the law of the land. And the idea that you should be able to hide behind, I guess I can't say the skirt, but really the kilt of the manly man, Iron John kilt of free speech jurisprudence, is to suggest basically that there is no protection for a private space or intimate relations in this country at some point, at some time, involving at least some people involve the exchange of sexy pictures. I don't think we have come to the place where we have said, you know what, it is beyond the traditions of the English-speaking, freedom-loving peoples that we want to create a legal and social environment where sharing one sexy picture with one person means sharing with everyone else.
I agree with you descriptively that those could be great arguments. I think where we're disagreeing is the extent to which Stevens forecloses them. I think you can make very good arguments that this should be in a realm that is as bad as the ones the court has previously recognized. And certainly the child pornography is a relatively recently discovered category. I just read Stevens as being very pessimistic that they're going to let that happen. And honestly, I think that's a good thing. I don't like the idea of the government continuing to come in and say, okay, this is low-value speech, we've decided, and therefore a different test applies to it. My thought is that when possible, we should use the existing mechanisms that we have to go after this. And to date, that's mostly been what's going on. Going after the people who use extortion, going after the people who use mail fraud, wire fraud, going after the people who use identity theft. That will certainly get some part of it. But you're right, the core problem is, what do we do about a situation where it's one person betraying their partner and putting that stuff out there? And I don't think as clearly as you do that the courts are going to accept that's outside the First Amendment. I think there are ways that we can go at it that make it fairly tough to prove up. That could be under some of the traditional categories. So there's a lawyer named Mark Bennett who writes a blog called Defending People. And he's engaged in this area, even though mostly criminal law is his part. And what he's said in response to all the proposed revenge porn statutes is that he thinks you should try to fit it under the obscenity rubric. So that when you're going through the traditional obscenity test and saying, would the average person applying contemporary standards find this appeals to prurient interest? Does it depict patently offensive things? And taken as a whole, does it lack serious literary, artistic, political, scientific value? That's the test that you do if you had a real life obscenity case in front of you. And Mark's point, and I think it's probably one of the best arguments for a revenge porn statute, is that if you take each of those elements and you say, taking in consideration the non-consensual nature of the depiction, or taking into consideration that this expression is of a deliberately taken a betrayal of a non-consensual expression of someone, think about that factor when you're deciding whether it's patently offensive. Okay? I think that is more likely to succeed in the long run, at least with our current Supreme Court, than is something that, in effect, attempts to create a new category. I see what Jim is saying about the zone of privacy that we should be able to have. And my concern is always going to be, I don't want to let the government into that zone. And if we let the government into the zone on the theory that, well, we should be able to prosecute people who leak the pictures of their boyfriend or girlfriend, how far else would we go into the zone? So I'd rather find another method. I'd rather find something under the existing categories.
Well, I think, and then here I'm going to appeal to Adam, because I know that he has extensive experience with the multiplicity of laws brought to bear. And I think it might be worth cataloging the three of us. And I think at this point we're all agreed, right, that any number of laws hacking into people's accounts is a violation of CFAA, right? The classic, whether it happens to a famous person named Aaron Andrews or it happens to someone down the street, no one knows. But sneaking into someone's house or hotel room and sticking a GoPro into the shower while they're taking a shower is trespass. It's any number of garden variety crimes, right? Let's keep going. Extortion, at least in California, not in certain other states, but California is deeply aggressive on that, and that's Kevin Bullard, made the unfortunate mistake among many in this life, including San Diego County. How about this one, right? I actually think that what Kevin did could be reached, and this is my way of getting to 230 eventually. It could be reached under an existing federal statute, namely Title 18, Section 1343, wire fraud. Right? What he did there was he effected a communication over wires, which by this time has been expanded to include the internet, in furtherance of a scheme or artifice for depriving another of money or valuable property or honest services, but we don't need to get that far. That's not the issue here, right? This is not the McNally issue or the Skilling issue. This is just classic mail fraud. Why can't we get someone like Kevin Bullard under mail fraud? And I'll just stop implicating with one more observation. I think it's worth thinking separately about retail and wholesale corners. Retail corners are the ones who go one person or one string of relationships at a time. This is the rogues gallery of all those stupid sluts who slept with me. Okay, that's the retail corner. The wholesale corner is the one that says, come one, come all, Kevin's Club, and post away. I think there is a distinction between those two, and that's exactly where the 230 issue comes up. But if you can think of other ways to reach this without creating a speech category or taking pot shots in the first amendment.
Well, when I made the pitch to the U.S. Attorney's Office here for them to go after Craig Pertain, and I haven't yet completely abandoned the hope like someday, but it's not looking promising. I said, look, you've got interstate extortion. You've got him saying in his David Blade hat, you have to pay me $350 to get this taken down. You've got wire fraud because he's using this fake identity to get people to send him money over state lines under the false pretense that he's someone other than the revenge porn sites. You've got mail fraud if the mails are used. And as you know, the feds, I used to love this. You can really reach almost any conduct with a federal law if you really want to. If you've done something, give me 2 hours in the federal code, and I think I could probably get it done. Okay. Mail fraud and wire fraud, all you need to show is that there was a scheme to get money, to get something of value, using fraud, and that the wires or the mails were somehow involved. That's it.
The stamp took a licking, the case keeps on ticking.
Exactly.
Okay, this looks like a perfect time. I know we have some people that might have some questions. We want to make sure we get to them before our short amount of time runs out. So if anyone has any questions for any of our panelists.
My question's for you, James. You've been stating that offenders who commit these acts should be gone after through other methods than First Amendment claim.
Well, I didn't say should, that's actually.
Can or are. How are victims protected from the proliferation of videos and images once they're received by other internet users? For example, if someone is indicted and convicted for wire fraud or whatever, and that person's found guilty, but another user has downloaded the pictures and videos already, and that person posts it online, how will that person get
This is, I'm glad you asked that question, because this gives me an opportunity to say, this is why I think the Title 47 United States Code, Section 230, should be reread. So I love the way that Adam says, well, everyone knows that Section 230 isolates internet service providers and website operators from liability. That may be the social meaning, but this is the whole point of going to law school. You look up the statute. And again, this is a rare thing for a Federalist Society speaker, but it also is law of the land, Justice Clarence notwithstanding. Also the history underlying the statute, the context in which the statute was passed, judicial interpretations of the statute, and little textual hints, okay? So Section 230 is actually titled. So maybe it is a familiar rule that a law has come to mean something, but it doesn't mean that at all because it's contrary to the words, to the history, and to its spirit. It's a great triple play. Holy Trinity Church versus United States. All right, so here we go. Section 230. The title of this section is Protection for Private Blocking and Screening of Potential Phishing of digital material. This is the statute that's supposed to protect website operators, right? Let's see about that. Subsection B, policy of the United States, to encourage the development of technologies which maximize user control over what information is received by individuals, families, and schools, to remove disincentives and for the development and utilization of blocking and filtering techniques, particularly that empower parents to restrict their children's access to objectionable or inappropriate online material, right? And finally, to ensure vigorous enforcement of federal criminal laws to deter and punish trafficking, obscenity, stalking, and harassment by means of computer. Now, if this is a law that's supposed to be the best line of statutory defense for Kevin Bullard and the people who magnify this kind of harm at the wholesale level, that's a really inauspicious start. Let's take a look at the actual section, the provision that Kevin will probably, and his lawyers will probably be raising on their appeal. There is subsection C, which is called Protection for Good Samaritan Blocking and Screening of Offensive Material. Whatever Kevin Bullard is, Good Samaritan is not one of them. No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. The key statutory distinction here is between someone who is an interactive computer service, that's the installation, but if you engage in providing information content, you are suddenly liable. Now, so it's one thing if you are Zuckerberg, you vaguely local guy somewhere else in the state. If Zuckerberg creates a site called Facebook and people post things on Facebook, that's the classic instance where someone is protected because all he is an interactive computer service. But at least one case has said that if you put up a site called badbusinessbureau.com and you invite people to trash businesses that they don't like, and then you add and heap onto it by throwing in section headings and things to tease people into trashing Chipotle or McDonald's or whatever. That makes you cross the line into being an information content provider. I submit that by creating a parallel site called cleanmyreputation.com, Kevin will cross that line. Okay, let's keep going. There's an argument here that federal criminal law is not at all affected by the state. So if there were a federal criminal law, yes, it would invite the federal criminal law. But that's okay. We don't need to get there because there's subsection 2 of section E. Nothing in this section shall be construed to limit or expand any law pertaining to intellectual property. Now, in this circuit, the Ninth Circuit, a case called Perfect 10 has said, oh no, intellectual property law means federal intellectual property law, so that state intellectual property law, such as the right of publicity or privacy, one or the other, would not qualify. That is not saved by this provision. Wait, let's see. This is a Christian affiliated school, and at least my branch of Christianity, we like to use the Latin language whenever possible. Okay, and you'll have to turn around and speak in Latin to just make the point really clear. But I'll give the order of the Coit Award to the first person who gets the legal principle award here. Subsection 1. Nothing in this section shall be construed to impair ... any federal, let me emphasize the word federal criminal statute. Subsection 2. Nothing in this section shall be construed to limit any law pertaining to intellectual property. What word is missing? Federal. Expressio unius as exclusio alterius. To say one thing in one section, that word federal in section 1 is not accidental. Its omission in section 2 has to mean something. Every word is sacred, every word is great. If a word is wasted, the law gets quite irate. This has got to be one of the weakest, lousiest claims of a defense I've ever seen. And let me put it to you one more thing. This is the Communications Decency Act. It's a separate title of the Communications Act of 1996. A statute I've written about many, many times, and it's this. Congress did not understand the internet well enough to even bother giving any remote guidance on whether the internet is a telecommunications service or an information service. Anyone who cares about net neutrality reads that 2 decades later and says, why? We didn't get any guidance on that. But Congress took special pains to think that the internet, they anticipated internet being the most useful vehicle for one thing, sexy speech. Congress thought that the internet would become the biggest porn bazaar on earth, B-A-Z-A-A-R. And you know what? They legislated on it. Section 230 is part of that law. And every clue that I've given you, from the title to the subsection title to the voluminous legislative history on this, points in the direction of saying this was all about giving website operators, internet service providers, and parents legal insulation from removing sexual pictures, not legal insulation to people who made a business practice of projecting involuntary sexual pictures to other people's detriment.
Okay, we only have about 3-4 more minutes, so I'll, well, I don't know, I'll leave it up to you to make this quick. You can. I think this sort of can go to anyone, but maybe Ken mostly. So I'm hearing that, okay, we all think revenge porn is bad, and, et cetera, we should stop it, but without a federal statute, or statutes in general, I'm curious where we find kind of the deterrence. Do you know what I mean? Because this is the internet. Once something's up there, we can do whatever we can and punish the guy, but that girl, or guy, but it's, the course of her life has changed forever. So,
and unfortunately, Streisand effect, any attempt to suppress the images, to get them taken away perversely, means far more people see them.
right.
So your question is, what can we do?
Well, right, so my question is, okay, in the absence of a new statute or something, because also, there's the argument, which I'm sure you're familiar with, the law's expressive value in kind of setting the tone,
Sure.
that this isn't tolerated in our society. So without enacting something new, I realize there are problems. How do we kind of combat that?
Well, I think by continuing the social consensus that this is unacceptable and vile, and by using the parts of the internet that are problematical to your favor. So when Mark Randazza and I saw Craig Brittain and got Adam involved, with Adam's rather frightening research and tracking people down skills. Within 2 weeks, his parents had kicked him out of the basement. Craig, not it. Sorry.
I'm still allowed in the basement.
He became a nationally known pariah. His partner, who famously sent me a message saying he was going to murder my brand, whatever that means, is bouncing from one pathetic job to another, this stigma of having been with this. I think that some of, we say too often that the response to bad speech is counter speech. And this is, it's hard to imagine worse speech, or a crueler, more destructive speech. But there really is an opportunity to, frankly, make these people's lives hell. And anyone who's doing revenge porn, I don't have any problem with the marketplace of ideas landing on them so hard that they don't get a job or a date for the rest of this decade.
Very quickly, I want to point something out too under the intellectual property thing. It is said that Section 647J as amended does not cover selfies. But let me remind you of something. When does copyright subsist in a work of authorship? The moment it's created and fixed. Who is the owner of the copyright? The person who takes the picture. Get it? By the way, you have a copyright interest, not just in the chattel. You can give away an image fixed in a particular picture or a file, but you didn't, by virtue of handing over that picture or file, necessarily license further distribution, and you retain the rights under the copyright law. So even a straightforward application of that law serves. And by the way, if you don't think that copyright has serious criminal sanctions, watch a video next time and see that little 10-second notice that it has to be there.
Well, thank you everyone for coming today. If you have more questions, I'm sure they'd be willing to stand outside for a couple minutes and answer them. So we'll see you same time, same place tomorrow for the last of the 3-day panel. So thank you. I know you all went to Starbucks before 5.
Almost canceled. Yeah, I saw that.